G'day and welcome to KPMG Ireland Legal Services Webcast on Evidential Requirements for Director Loans. My name is Rosanne O'Connor and I'm an Associate Director with the KPMG Ireland Legal Services team, specialising in mergers and acquisitions, shareholder arrangements and corporate restructuring. Today I am going to talk to you about the new Evidential Requirements for Director Loans, which have been introduced by the Companies Act 2014. I will give you an overview of the relevant provisions, followed by a recommendation on what you need to do to ensure your arrangements are not affected by those provisions. Think about the corporate structures you have in place. Has a director of a company or a person connected with that director made a loan to the company? Alternatively, has the company made a loan to one of its directors or a person connected with that director? The much anticipated Companies Act 2014 came into force on the 1st of June this year, and with it introduced new evidential requirements for loans to and from directors. It is important to note at this point that the new Act has not substantially altered the general prohibition on loans from companies to its directors or persons connected with those directors. The new Act largely replicates the old Act on this score. Therefore, loans, quasi-loans, and other credit and security arrangements from a company to a director or a person connected with that director continued to be prohibited unless they come within the noted exceptions, the key ones being that the loan is an intergroup loan, i.e. from the company to its holding company or a subsidiary of its holding company, or that the value of the loan is less than 10% of the assets of the company, or that the loan has been approved using the new summary approval procedure. So assuming the loan from the company to the director is permitted, what are the new evidential requirements that have been introduced? Section 236 of the Act deals with loans from a company to its directors and provides that in relevant proceedings, that is, civil proceedings, where it is claimed that a company has made a loan to a director of the company, a director of its holding company, or a person connected with the director of any such company, then if the terms of that loan or quasi-loan are not in writing or are in writing but are ambiguous as to their terms of repayment, then it shall be presumed until the contrary is proven that the loan or quasi-loan is repayable on demand and that it bears interest at the appropriate rate until it is repaid. The appropriate rate is currently set at 5%, and this may be amended by ministerial order. So I have mentioned persons connected with a director. Who does that cover? A connected person is rather widely defined under the Act and includes a director's spouse, civil partner, brother or sister, or child, including the child of a civil partner and who is ordinarily resident with the director and civil partner. A body corporate shall also be connected with a director if it is controlled by that director or by another body corporate controlled by that director. Section 237 of the Act deals with loans from a director to a company and provides that in relevant proceedings, that is, civil proceedings where it's claimed that a loan or a quasi-loan has been made by a director of a company to the company or to its holding company, or by a person connected with such director to that company or its holding company, then if the terms of that arrangement are not in writing or are in writing or are partially in writing, but ambiguous as to whether the arrangement actually constitutes a loan, then it is presumed, unless the contrary is proven, that the arrangement is not in fact a loan or a quasi-loan. The Act does not go on to specify what the arrangement is then to be classified as, and this could leave the director or the connected person in the unenviable position of having to prove that the advance made by it to the company was not a gift or indeed a capital contribution. Section 237 goes on to provide that in relevant proceedings, where the arrangement in question is proven to be a loan but the terms of the loan are ambiguous as to whether the loan bears interest, then there is a rebuttable presumption that the loan does not bear interest. If the terms of the loan are ambiguous as to whether the loan is secured, then it shall be presumed unless otherwise proven that the loan is unsecured, and where the loan is proven to be secured but its terms are ambiguous as to the priority of the loan vis-à-vis other debts of the company, then there is a rebuttable presumption that the loan is subordinate to all other debts of the company. So what do these provisions mean for you? You need to ensure that going forward, all loan arrangements between companies and their directors, or persons connected with those directors, are fully and specifically documented, with particular attention given to interest rates, repayment terms, security, and priority. You also need to consider existing loan arrangements that are in place between a company and its directors, and where those loans are not currently in writing, whether it would be prudent to now document those arrangements. Directors do not want to find themselves having to prove that monies advanced by them to a company was a loan and not a gift. Clear and specific documentation can avoid this issue arising. If you would like to discuss any of the topics raised in this webcast, or if you have arrangements in place that you feel should now be documented, please do not hesitate to contact me. You can also connect with me on LinkedIn. For further information on the Companies Act, please visit our website at kpmg.ie/Companies Act. If you have not done so already, you can also sign up for our tax app, where you can access a range of in-depth articles and publications. Thank you for watching this webcast. I hope you found it useful, and I hope to speak with you again soon.